We have heard one after the other representatives of the two main unions representing some 7,600 taxi operators, that is the Taxi Proprietors Union and the General Taxi Owners Union. We have thus taken stock of their perspectives, concerns and proposals regarding the operation of the digital taxi booking applications with a view to determining the best way forward in the interest of the taxi community as well as users of taxi services. Furthermore, during the meeting of 11 June 2026, the representative of the Taxi Operators Welfare Fund presented the new website of the fund to those present, much to the satisfaction of the representative of the unions, I must say. Mr. Deputy Speaker, during the said meeting, we were informed by the President of the Taxi Proprietors Union that a dozen or so online platforms for booking of taxi services are in operation in Mauritius. Indeed, since 2006, beside Alalida, there are other companies like Yugo, Dodogo, Finova, Motaxi, amongst others, that are providing similar online services, each having a certain number of taxis already registered with them. The matter has, however, aroused concern now among some taxi operators as Alalida has recently launched a new interface powered by the Uber technology, where it has stepped up efforts of canvassing operators to register the new platform to expand its digital reach. The representative of the Taxi Proprietors Union has further stated that at the Ministerial Committee that he is against the operation of Alalida, as there is an apprehension among taxi operators with regard to the matter in which Uber operates elsewhere, and that taxi operators fear that their business would be adversely impacted upon, and hence the reason for lodging the court case. They also apprehend a gradual increase in the commission that will apply over time. On the other hand, the General Taxi Owners Union is for the operation of Alalida with its new interface powered by Uber technology. It considers that Alalida will bring much benefit to taxi operators. Hence, I have to point out that the two main unions are highly divided on the question, and so is public opinion gauged from comments on social media. Mr. Deputy Speaker, with regard to Part B of the question, I have to inform the House that no approval has either been sought from nor has been granted by the NLTA authorizing Alalida or any similar platform to operate. In fact, there is presently no provision under the Road Traffic Act governing the operation of online taxi platforms, and the NLTA does not interfere, therefore have any legal jurisdiction in that respect. To end, Deputy Speaker, sir, I have to highlight that this matter remains a high concern for government. To that effect, I wish to guide the Honourable Member to annex to the budget of 26-27, that is what was presented the week before, wherein provision has been made at paragraph 16E for strengthening of the regulatory framework governing online taxi booking platforms with a view to ensuring that such taxi services are safe, transparent and reliable. The Ministerial Committee, which I chair, which will submit its recommendation to government for a policy decision soon. Thank you.
Yes, you have a supplement.
Merci, Monsieur le Vice-président. L'honorable ministre peut-il nous dire s'il est au courant du nombre d'opérateurs qui sont regroupés justement sous la plateforme Uber, region-wise si possible, et combien d'opérateurs de taxi font partie de la plateforme à ce jour?
Deputy Speaker, sir, I don't have that figure. I will have to ask that information from the NLTA or that company.
Monsieur le Vice-président, donc avec votre permission, l'honorable ministre peut-il révéler à la Chambre si une étude a été réalisée pour savoir l'impact de l'introduction de ce service sur les chauffeurs de taxi à travers l'île, et si oui, d'en donner plus de détails, et si jamais ce n'est pas le cas, s'il compte le faire à l'avenir?
As I have stated, Deputy Speaker, the budget makes provision for us to come up with a regulatory framework on the subject, And as such, I think consultation will shed much light on this question.
Yes, one question, Honorable Bichuk. One supplementary.
Can the Honorable Minister explain to the House how these online booking platforms happen that they urge or enable taxi operators to open outside their bars d'opération, whereas it is clearly stated in the law that our PSV taxi licenses are provided for operators to operate in a specific area known as base opération.
Yeah, okay. I would like to guide the honourable member to jurisprudence on that question. In the case of Reading Borough Council versus Mudassar Ali in the UK, dated 24 January 2019, wherein it is stated the base of operation is one thing if you take a client physically on that base of operation, but if it is done through telecommunication media, the issue is highly questionable. So in due course, when the time comes for the preparation of that framework that I just mentioned, we'll take that question on board.
The Honorable Second Member for Flac Bonacay.
Oui, Monsieur le Vice-président, B 927, s'il vous plaît.
Mr. Deputy Speaker, sir, at the 114th session of the International Labour Conference in Geneva, I had bilateral meetings with ministers of labour and employment of several countries, namely India, Nepal, Madagascar, Bangladesh, Saudi Arabia, Morocco, Rwanda, Ghana, and Botswana. The discussion with labour ministers of countries who send workers to Mauritius generally centered around collaboration between our countries to promote the ethical recruitment of workers, and in particular to ensure that foreign workers are not exploited and do not have to pay any fees regarding their recruitment. Discussion also covered the rights of migrant workers and access to social protection. Mr. Deputy Speaker, sir, with regard to the bilateral meeting I had with the Minister of Labour from Bangladesh, I explained to him the situation of Bangladeshi workers in Mauritius. I informed him that in 2023, the previous government had put a stop on the issue of work permits to new Bangladeshi workers because of the high number of Bangladeshi workers who left their employment to work illegally. I explained to him that following the report of the Interministerial Committee on Work Permit Issues, government had, in September 2025, agreed to the resumption of recruitment of workers from Bangladesh in the bakery, textile, printing, press sector, and other scarcity areas. I, however, pointed out that the number of Bangladeshi workers who are missing and have left their jobs to work illegally for other employers are unacceptably high. The Minister of Bangladesh informed me that in order to ensure the ethical recruitment of workers from Bangladesh, it was necessary to eliminate the middlemen in Bangladesh, and he recommended that henceforth all recruitment be done through the Bureau of Manpower, Employment and Training and the Bangladesh Overseas Employment and Services Limited, which are Bangladeshi regulatory authorities facilitating labour migration and overseas employment in Bangladesh. The workers will be screen tested before coming to Mauritius, and this will avoid the risk of them leaving their employers to take up employment elsewhere illegally. We agreed to sign a memorandum of understanding in that respect. A draft MOU has already been worked out and is presently under review. The MOU will be forwarded by my ministry to the Ministry of Foreign Affairs, Regional Integration and International Trade for onward transmission to the Bangladeshi authorities for their consideration, following which approval of government will be sought for it signing by both countries. Mr. Deputy Speaker, sir, let me be very clear. It is not the policy of government to favor the recruitment of Bangladeshi workers at the expense of workers from any other nationality. Recruitment of foreign workers is strictly demand-driven. And I would like to point out that back in November 2024, when I assumed office as Minister of Labour and Industrial Relations, there were already 10,672 Bangladeshi workers in Mauritius, and today there are currently 8,975 Bangladeshi workers, which is actually less than when I took office.
Yes.
Yes, thank you, Mr. Deputy Speaker. Can the Honourable Minister either tell us or table to the Assembly the list of scarcity areas where currently work permits are being allocated to Bangladeshi nationals?
Yes, Mr. Deputy Speaker, sir. Actually, the list is worked out by the HRDC, the Human Resource Development Council. We have the list of scarcity areas, sector-based. So the list is available on their website, but I can communicate a list to my learned friend.
Yes.
Yes, thank you, Mr. Deputy Speaker. In a reply to a PQ put by Honourable Joanna Béranger in this House, the Honourable Minister had stated that 80% of missing foreign workers in Mauritius are Bangladeshi nationals. My question, therefore, pending the resolution of this long-standing, worsening social issue and the rising number of crimes involving Bangladeshi nationals, will the Honourable Minister consider simply ban or freeze the allocation of new work permits to Bangladeshi nationals?
Mr. Deputy Speaker, sir, the decision to resume the recruitment of workers from Bangladesh was taken by Cabinet, and it's only Cabinet who can override this decision. But I would like to reassure the Honourable Member that Bangladesh is one of several countries that falls under the 11th schedule of the passport regulation. And anyone who comes from those countries require enhanced security clearances from the Prime Minister's office. So before any any work permit is issued to any worker from Bangladesh, it has to clear the necessary security screening at the level of the Prime Minister's office.
The Honourable Third Member of Portary South and Portary Central.
B928, please.
Mr. Deputy Speaker, sir, I'm informed by the Forestry Service that 10,270 hectares of state land falling under its purview have been earmarked for shooting and fishing and ecotourism purposes. In this respect, 54 leases covering a total of 8,696 hectares have been granted under the Shooting and Fishing Leases Act for the purpose of shooting, fishing, and ecotourism activities. I have to inform the House that out of these, 48 leases were granted by the previous regime during the period June 2021 to September 2024. Mr. Deputy Speaker, sir, since November 2024, the Minister of Agro-Industry, Food Security, Fisheries, and Blue Economy has granted 6 shooting, fishing, and ecotourism leases, and for these applications, due diligence exercises were conducted first by the Forestry Service. The applications were thereafter examined by a shooting and fishing steering committee chaired by the senior chief executive of the ministry. This committee comprises of representatives: 1, the Corporate and Business Registration Department of the Ministry of Finance, the Ministry of Tourism; 3, the Registry of Association of the Ministry of Labour and Industrial Relations, the Mauritius Police Force, the Forestry Service, and the National Park and Conservation Service. It was only following the favourable recommendation of the committee that the grant of the leases was approved by the ministry pursuant to Section 3(1)(c) of the Shooting and Fishing Licenses Act. Now, with regard to Part A of the question, a shooting and fishing lease is granted for a period of 7 years. The lease may be extended for another 7 years up to a maximum of 14 years, provided that the lessee has properly preserved the game and duly fulfilled the conditions of the lease. On the other hand, an ecotourism lease may be extended such that its total duration does not exceed 20 years. As regards Part B of the question, Mr. Deputy Speaker, I'm informed that by the Forestry Service, that 4 leases have been cancelled and 2 leases have not been reviewed over the past 3 years. The 4 leases that have been cancelled are: 1, the lease granted to Ecodia Park Association of a state land, Diet and Margin, of an extent of 250.76 hectares. The lease was cancelled with effect from 9th March 2023, as the lessee had undertaken activities that were outside the ambit of the lease and of the applicable legislation specified in the lease. At that time, the then Independent Commission Against Corruption was investigating into an alleged case of corruption involving the former Minister of Agro-Industry and Food Security, and an alleged case of money laundering connected with the association. Secondly, the lease granted to Agri-Hunt and Lodge Limited of a part of state land, Good End, of an extent of 75.69 hectares was cancelled on the 17th January 2026, as the lease had failed to settle rent for a period 8 September 2025 to 7 September 2026 by the set deadline of the 1st of April 2025, which had been extended twice up to October 2025. 3, the lease held by Green Force Forest Company Limited over state lands, Kitri, Rotary, and Rampal, of an extent of 64.75 hectares, was cancelled on the 4th April 2026 upon the request of the lessee. Finally, the lease granted to Société Hémisphère de l'Est over state land, Descent, and Valton Rochery, Leclerc, and Galanterie, of an extent of 178.68 hectares, was cancelled on the 25th May 2026 in view of the several breaches of the Lease and Shooting and Fishing Leases Act. The lessee had failed to settle the annual rent for the period 8 September 2026 to 7 September 2027 by the statutory deadline of the 1st April 2026. It had also failed to properly maintain the state land and did not employ any watchmen for the site as required under the Act. Mr. Deputy Speaker, as regards those leases which have not been renewed, there is firstly the lease held by Chassé de la Rivière du Poste Limited over state land Salazie and Bovalo of an extent of 78.98 hectares. I'm informed that the lease was not renewed as there had been several breaches of the Lease and the Shooting and Fishing Leases Act, including late payment of rental fees and encroachment upon plot of state land of over 4 hectares. Furthermore, following the recommendation of the Shooting and Fishing Steering Committee, the Ministry did not approve the renewal of the lease held by First Direct Resort Limited of a part of state land Raoul of an extent of 175.18 hectares for the period 25th May 2019 to 24th May 2026. Contrary to the provisions of the Shooting and Fishing Leases Act and the condition of the lease, the lessee failed to carry out shooting and fishing and ecotourism activities and made no provision for any watchmen on site. Mr. Deputy Speaker, I have to reassure the House that leases for shooting and fishing and ecotourism purposes are being allocated in line with good governance practices.
Yes.
Thank you, Mr. Deputy Speaker, and thanks to my very good friend for his very explicit answers. May I ask the Honourable Minister whether if cannabis cultivation has been found on certain of these, not the ones you mentioned, but any of the lease land, does that entail automatic cancellation of the lease?
I don't know, I'd be surprised if there's been cultivation of cannabis, but as far as I know, it doesn't entail immediate cancellation because we don't know who is the person who's growing the cannabis. Doesn't mean that necessarily it has to be the lessor.
The Honourable Third Member for Port Resource, Tylon.
Thank you, Mr. Deputy Speaker, sir. B 929.
Thank you very much. Mr. Deputy Speaker, I'm informed that the plot of land referred to at Richter in Terre Rouge is in fact state land, currently leased to a private company under a 60-year lease expiring on the 30th of June 2073. The question of assessment for housing development, therefore, in respect of that site, does not arise. I must also add, Mr. Deputy Speaker, sir, that this is a site that is found in a totally industrial area, as the Honourable Member is well aware, and it would not be proper to consider putting a housing development of this nature, as suggested by the Honourable Member, in the middle of an industrial zone. That would not be improper, and it would be an insult to those we may contemplate giving houses to. So that is the answer. Thank you.
Yes, you have a supplement?
Considering that currently this plot of land being transformed into a dumping area, may I request the Honourable Minister whether consultation can be carried out with other ministries, such as Ministry of Environment, so that proper works can be done to prevent this site from being further degraded. Thank you.
Mr. Deputy Speaker, sir, I am informed, since the Honourable Member has put this supplementary question, I may add the following. The company in question that holds the industrial lease was for running a factory of manufacture of wax, grease, lubricants for sewing machines, engines, power generators, mechanical and electrical equipment over part of state land at Richter. And that was dating back to 2013. Now, the Ministry was informed, as at the 5th of November 2024, by the receiver manager, that's PricewaterhouseCoopers, that the company is now in receivership. As it stands, I am informed that the receiver manager has contacted my ministry for the proposed transfer of the above-mentioned lease to a new company altogether, who has decided to purchase all those the assets or the leasehold rights. Now, rent for the site has been paid up to the 30th of June 2020, and a notice has been issued to the lessee on the 1st of June 2026 to pay all outstanding rent not later than the 30th of June, which is today, failing which the Minister will consider cancellation. So as it stands, the person responsible is the administrator, even for cleaning of that plot of land. So since there is a new person coming in that will be taking over the place, I can most probably, you will agree with me, Mr. Deputy Speaker, said that there would be no issue of dumping or whatsoever in the near future. Thank you.
The Honourable Fourth Member for Reading.
Mr. Deputy Speaker, sir, B 930.
Mr. the Deputy Speaker, sir, since joining SADC in 1995, Mauritius has actively participated in the drafting, signature, ratification and implementation of SADC protocols across a wide range of sectors. As at date, Mauritius has signed 28 SADC protocols, out of which only 26 have been ratified. Regarding domestication, the information is not available at my ministry, as same falls under the purview of the line ministries. Mr. the Deputy Speaker, sir, the two SADC protocols not yet ratified are the SADC protocol on statistics and SADC protocol on the tribunal. With regard to the protocol on statistics, which Mauritius signed in 2023, consultations are ongoing at the national level with a view to its ratification. As regards the protocol on the tribunal, which Mauritius signed in 2017, the instrument seeks to reestablish the SADC Tribunal as a regional judicial body to adjudicate disputes under a revised mandate and structure. The protocol is currently under national consideration in view of its complex legal, financial, and institutional implications. In accordance with established practice, each SADC protocol is reviewed by the relevant line ministry in consultation with the Attorney General's Office, the Ministry of Finance, my ministry, and other stakeholders to assess its legal, financial, policy, and institutional implications prior to signature and ratification. Cabinet approval is subsequently sought by the responsible line ministry. The instrument of ratification is signed and deposited with the SADC Executive Secretary through the appropriate diplomatic channels. May I, with your permission, Mr. the Deputy Speaker, sir, table a list of all the SADC protocols that have been ratified by Mauritius. Thank you.
The Honourable Third Member for Flag Bunakahi.
Mr. Deputy Speaker, sir, B931.
Monsieur le
Yes, Honourable Minister.
D'exploitation, notamment les 30 juin 2025, la CWA a enregistré un déficit de 755 millions de roupies. Selon son passif total s'élève actuellement à 11,2 milliards de roupies. Selon la CWA, les principaux facteurs ayant affecté sa situation financière sont les suivants. Le transfert de vente d'eau, l'eau pompée des boreholes de la CWA sont envoyés directement au Consolidated Fund, pas dans les comptes de la CWA depuis juillet 2009. L'absence de révision tarif de l'eau depuis janvier 2012, ce qui a conduit à une situation où le coût de la fourniture d'eau est à 24 roupies mètre cube, ce qui dépasse largement les recettes générées par l'eau vendue à 14 roupies mètre cube. Donc 10 roupies par mètre cube qui est perdu. Il y a aussi l'augmentation significative de plus de 20%, passant de 4,8 millions de roupies à 17,8 millions de roupies du prix des produits chimiques tels que chlore, la chaux, autres qu'on met dans l'eau, et aussi une augmentation des coûts d'électricité, entre autres. Il y a d'autres raisons aussi. Donc, Monsieur le Vice-président, ce jour, le montant total dû au gouvernement mauricien par la CWA s'élève à 3,47 milliards de roupies. De ce montant, les arriérés représentent 2,92 milliards de roupies. La CWA m'informe, Monsieur le Vice-président, qu'au 25 juin 2026, donc ce mois-ci, le montant total des paiements dus aux entrepreneurs, prestataires de services, fournisseurs s'est élevé à environ 697 millions de roupies. Sur ce montant, 470 millions de roupies sont dus à la Central Electricity Board, au titre des factures d'électricité accumulées depuis plusieurs années. Comme mentionné, Monsieur le Vice-président, plus tôt, chaque mètre cube d'eau produit par la CWA revient actuellement à environ 24 roupies le mètre cube, alors qu'il est facturé à 14 roupies. Cet écart important, Monsieur le Vice-président, entre le coût réel de production et le tarif appliqué pose un véritable défi de soutenabilité financière pour le service public de l'eau à moyen et long terme. Dans ce contexte, une réflexion est en cours afin de revoir cette équation tarifaire et d'assurer un meilleur équilibre entre les coûts de production et les revenus générés par le service. Toutefois, je tiens à préciser que toute éventuelle révision concernera uniquement les consommateurs non domestiques. Il n'est nullement question d'alourdir la charge des ménages, notre priorité demeurant la préservation du pouvoir d'achat des familles mauriciennes. Monsieur le Vice-président, pour terminer, je souhaite également attirer l'attention de cette Assemblée sur le cas de certaines entreprises qui utilisent l'eau distribuée par la CWA à des fins commerciales. Dans certains cas, l'eau contenue dans une bouteille qui est vendue dans les supermarchés représente un coût d'à peine l'eau entre 3 sous et 5 sous. Nous savons tous combien une bouteille d'eau est vendue sur le marché. Il est donc légitime, je l'ai dit avec sérieux, il est donc légitime de s'interroger sur la contribution de ces usagers commerciaux à la pérennité du service public de l'eau et de veiller à une utilisation plus équitable de cette ressource nationale. Dans cette optique que d'ici quelques mois, des nouveaux barèmes tarifaires seront en vigueur pour certains secteurs. Merci, Monsieur le Ministre.
Right. The table has been advised that the following PQs have been withdrawn. B2, B933, 950, 955, 956. Honourable Third Member for Bobassa, Petite Rivière.
B932.
Mr. Deputy Speaker, sir, I'm informed that on the 19th January 2026, a tender exercise was launched through the restricted bidding procurement method. Though the e-procurement system by my ministry for the replacement of floodlights at Saint-François Xavier Stadium. The estimated cost of the project was 2,900,000 rupees, excluding VAT. And the closing date for the submission of bids was on the 9th February 2026. 20 potential bidders were invited to bid. On 10 February 2026, the bids were open and only 2 bidders had quoted for the project, namely Moritech Limited with a bid value of 3,469,200 rupees, excluding VAT. Secondly, Kabilek Engineering Limited with a bid value of 2,214,000 rupees, excluding VAT. Mr. Deputy Speaker, sir, as per the normal procurement procedures, a bid evaluation committee was set up at the level of my ministry to evaluate the bids and to make appropriate recommendations. It is worth mentioning at this stage that an essential aspect of this procurement exercise was the preparation of the technical specification for the floodlights, which was done by an electrical engineer, senior electrical engineer from the Energy Services division of the Ministry of National Infrastructure. In addition, an officer of the same grade from the ESD formed part of the bid evaluation committee to evaluate the bids. Hence, during the evaluation, the BEC noted that Kabilek Engineering Limited has not met technical criteria regarding the requested power factor, technical specification for the proposed model, and proposed simulation of the Lux level distribution map. The BEC requested that the bidder submit the additional information regarding those missing information. The additional information as submitted by Kabilek Engineering Limited did not satisfy the BEC, and the bid was not retained. It did not proceed to the financial evaluation. On the other hand, the BEC found that Moritech Limited has satisfied all the qualification criteria and technical requirements as per the tender documents. Hence, the bid was considered to be substantially responsive. Mr. Deputy Speaker, I wish to point out that Moritech Limited had quoted a bid amount which was 90% higher than the cost estimate. Directive number 16 of the Public Procurement Office provides that negotiation may be undertaken with a bidder whose bid is substantially responsive and does not exceed the cost estimate by more than 25%. Accordingly, a negotiating team was appointed to invite the bidder to submit its best and final offer. Following negotiation, Moritech Limited was awarded a contract for a contract value of 3,300,000 rupees, excluding VAT.
Président, à un moment où on demande à la population de faire des économies, où le gouvernement lui-même devrait faire des économies, nous constatons qu'on a alloué le contrat à une entreprise qui a coté 1 255 000 de plus que son concurrent. L'honorable ministre ne pense-t-il pas, dans un contexte actuel difficile, il faudrait relancer un exercice d'appel d'offres de façon à ce qu'on ait plus de soumissionnaires, de façon à ce qu'on puisse réellement faire le choix qu'il faut et allouer le contrat à un prix raisonnable comparé, il vient de le dire lui-même, il alloue le contrat 90% plus cher que le montant qui avait été initialement préconisé.
Answer to the question. We had 20 potential bidders that was invited for the bid. And we have to go for regulation. We cannot bypass the regulation of what's been established. So if we don't do that, that means we are bypassing the regulation of a bidding exercise.
The Honourable Third Member for Vieux-Grand-Port, Roseville. That is withdrawn. The Honourable Third Member for Flac-Bonacay.
Mr. Deputy Speaker, sir, B934.
Thank you very much. Mr. Deputy Speaker, I'm informed by the Division of Veterinary Services of the Ministry that as matters presently stand, the importation of Panganur dwarf cattle from India into Mauritius cannot be envisaged. The implications associated with any potential importation of the cattle would include, inter alia, 1, the risk of introduction and spread of the foot and mouth disease and other transboundary animal diseases in Mauritius. 2, the possible loss or suspension of the country's sanitary status in respect of international animal health standards. 3, increased veterinary surveillance, quarantine and biosecurity requirements. 4, additional financial and operational implication for disease prevention, monitoring and contingency preparedness. And 5, potential adverse repercussion on the local livestock sector and related economic activities. Mr. Deputy Speaker, sir, I'm further informed that the Panganur dwarf cow is an indigenous and endangered cattle breeding originating mainly from Andhra Pradesh, India. It is recognized as one of the world's smallest hump cattle breeds with a height of approximately 70 to 90 centimeters, weighing between 115 to 200 kilograms. The resilient and docile cattle is known for producing milk with high butter fat content of around 8%, making it suitable for small-scale dairy farming systems. Mr. Deputy Speaker, sir, all imported live animals, products of animal origin, for human and non-human consumption, are subject to stringent sanitary and veterinary and biosecurity requirements and should be accompanied by import permit delivered by the Department of Veterinary Services as stipulated in the Animal Disease Act of 1925 and regulation. The import permit is designed to protect the country against sanitary threat in line with sanitary and phytosanitary measures of the World Trade Organization, which lay down all animal health and veterinary public health conditions to be complied with and certified by the official veterinary authority of exporting country. It is to be noted that the Attorney General's Office is currently drafting the Animal Health, Veterinary Public Health and Livestock Production Bill. The main object of the draft bill is to promote and protect animal health and veterinary public health. The Animal Disease Act of 1925 will thereafter be repealed. It is important to highlight that India is not recognized by the World Organization for Animal Health as a country free from foot and mouth disease. Nevertheless, it is in the process of creating a foot and mouth disease-free zone and compartment as per guidelines of the World Organization for Animal Health. Mr. Deputy Speaker, in view of the prevailing animal health situation in India with regard to foot and mouth disease, and taking into consideration the need to safeguard the sanitary status of Mauritius, we might as well opt for a precautionary approach, and we hope that this will be maintained, and we'll see how things evolve. Okay? Yeah.
The Honourable Fourth Member for Wardig.
Mr. Deputy Speaker, sir, B935.
Mr. Deputy Speaker, sir, as we debated this morning, the National Pension Fund, NPF, was established under Section 37 of the National Pensions Act, and contributions into the fund were made by insured persons in employment in accordance with Section 13 of the same Act. Self-employed and non-employed persons could also contribute voluntarily into the fund under Section 88 of the National Pensions Act. However, as we stated this morning, the previous government discontinued the contribution scheme and introduced the Contribution Sociale Généralisée, CSG, as from 1st September 2020. Contributions are now made to the Mauritius Revenue Authority, MRA. Under the National Pensions Act, insured pensions who had contributed to the National Pensions Fund may qualify for the following contributory benefit. And for the benefits which are intended to provide income protection in case of retirement, invalidity, death, or employment injury. First, contributory retirement pension, CRP. 2, invalids pension contribution, CIP. 3, widows and widowers contribution pension. 4, orphans contributory pension. 5th, industrial injury benefits. Mr. Deputy Speaker, sir, with regard to Part B of the question, I'm informed that as at date, there are 1,151 fishermen in Rodrigue who have contributed as self-employed in the National Pension Fund. Out of the 1,151 fishermen, 418 are in receipt of contributory retirement pension and invalids contribution pension. I am further informed that there are 333 fishermen who are not in receipt of any contributory benefit for the following possible reasons. A, the contributor has not reached 60 years or retirement age to claim the CRP. B, the contributor may have passed away before his or her entitlement to claim the CRP. C, the contributor may have started to contribute to the National Pension Fund in 2012 and have less than 150 pension points to be entitled for a minimum CRP. D, claims for contributory benefits have not been made due to ignorance, and E, contributor was not an insured person in the financial year preceding their claim to contributory pension, CRP or CIP. Thank you, Mr. Deputy Speaker, sir.
Yes.
Mr. Deputy Speaker, sir, thank you. May I ask the Honourable Minister, for those fishermen who are not in receipt of pensions and who do not meet the criteria, what will happen to their contribution? Will they be refunded?
All contribution made is in the fund, is safely in the fund, and will be paid to the contributor when the contributor meets all the criteria. I can even disclose to the House that the total amount of contribution paid, of NPF contribution paid by the fishermen in Rodrigue, which is 100,500, is 7,899,925 rupees. So they have been contributing. They are entitled, as a matter of right, to the contribution, to entitlements under law.
Yes.
May I ask the Minister, for those who are already 60 years old and before 2025 and who have not received the pension, what will happen to their contributions?
As I told you, there are many reasons why a contributor might not have been receiving his or her pension. I'm not informed of any particular such case. If you have any particular such case, please inform me. I will look into the matter. What are the reasons of this? But the possible causes are as listed in my answer.
This question is for fishermen in Rodrigue. Thank you. Honorable Annabelle.
Merci, Monsieur le Vice-président. Question B936.
Mr. Deputy Speaker, sir, I wish to inform the House that my ministry has taken note of 2 photographs and a video circulating on social media allegedly showing health personnel at Victoria Hospital in intoxicated state. In fact, these photographs and the video appear not to be recent ones, as the environment is currently not the same as depicted. It is difficult to identify the 2 persons depicted in the photograph, as their faces are not visible while being in a sitting position. However, as regards the video recording, where an employee is admitting taking illicit substances, the said employee has been identified. He has been interdicted from exercise of the powers and functions of his office as attendant on shift on a casual basis with immediate effect under Regulation 31(1) of Public Service Commission's Regulation 1967, as subsequently amended as from 16 June 2026. I'm further informed that this employee was recruited in 2022. As at date, he had not yet been appointed in a substantive capacity due to his recurrent misbehavior, bad conduct, frequent absenteeism, and ongoing police case. The police case is yet to be finalized. An investigation committee has been set up to look into the matter. The committee will also investigate into all suspected or reported cases of employees under the influence on intoxicating substances and making appropriate recommendations accordingly. In the meantime, 2 other employees who were suspended of taking drugs or other intoxicating substances have been transferred to other hospitals. With regard to part A of the question, the inquiry is still ongoing, and my ministry will take appropriate actions in the light of findings thereof. With regard to part B of the question, I wish to inform the House that the Code of Ethics of Public Officers stipulate that they shall not consume any alcoholic drink, nor use and/or abuse illicit drugs or controlled substances. Consuming alcoholic drinks in a public place, which also includes a workplace, is an offence under the Public Health Act. On conviction, any person is liable to a fine not exceeding 10,000 rupees and imprisonment for a term not exceeding 12 months under Public Health Act. In addition, public officers are not allowed to smoke any tobacco product while on duty or in any public place or any other indoor area which is open to the public or where the public is permitted to have access. The offender is liable to a fine of not less than 5,000 rupees and not exceeding 10,000 rupees and to imprisonment for a term not exceeding 12 months. My ministry has taken the following measures to sensitize personnel in medical institutions on not consuming alcohol and illicit substances thereat. Continuous supervision, monitoring by heads of department and supervisors and conduct of supply checks, particularly during night shifts, to ensure compliance with the standard of conduct expected of public officers. A referral of officers when necessary for assessment, treatment, including counseling and psychosocial support at specialized centers, namely Dr. Jitu Hospital and Ram Sequoia Mental Health Care Center. Awareness programs on the ill effects of substance abuse, working sessions held with ATSU to sensitize health personnel on substance abuse and setting up of a flying squad to search staff for any illicit products. Issue of a circular to inform officers on the consequences of consumption of alcoholic drinks during official hours, and disciplinary procedures according to Regulation 36 of the Public Service Commission in case of misconduct.
Yes, Honourable Member.
Merci, Monsieur le Vice-Président. Will the Honourable Minister confirm whether there is a direct link of illicit consumption of cough mixture and the personnel who were under the influence of drugs, keeping in mind that a half-filled, unsealed cough mixture bottle was disposed by pharmacy of Victoria Hospital?
Mr. Deputy Speaker, sir, my question is related to the utilization of alcoholic drinks in hospitals. This had nothing to do with the issue that the Honourable Member is raising. It had never been proved in any way. We have investigated and we find these are separate issues. The issue about which she has asked me is a question that concerns drunkenness, illicit liquor and drugs in hospital.
Yes.
Pour répondre à la question de l'honorable ministre, peut-il dire si des surprise checks sont organisés par sa hiérarchie pour s'assurer du bon fonctionnement dans les hôpitaux publics et qu'en est-il, que fait-il pour résoudre ce problème?
Mr. Deputy Speaker, sir, even I visit hospitals regularly at night, and my state of health has gone down as a result of repeated regular visits at night these days. I do it. My officers are doing it. I'm not in a position to tell you whether we're going to attain 100% success, because whenever they consume alcohol, they will never do it in my presence. But I can assure the House that the maximum is being done in order to control those bad elements in our hospitals. I have not recruited them. Unfortunately, they are here since long.
The Honourable Second Member for Vieux-Grand-Port and Roseville.
Thank you, Mr. the Deputy Speaker. Sir, it's question B/937, please.
Mr. Deputy Speaker, with your permission, I would like to answer to both PQ 937 and 948 together, as they relate to artificial intelligence in the Republic of Mauritius, which also includes Rodrigues. So, as we all know, Mr. Deputy Speaker, AI is transforming every aspect of our society across sectors like health, education, financial services, justice, public administration, and social media. While this philosophy, I would say, AI presents significant opportunities to enhance productivity, to improve public service and drive economic growth, it also presents challenges and challenges that are worsening for our society. This includes, as rightly pointed out by the member, the creation of deepfakes, spreading of misinformation, disinformation, malinformation, privacy breaches, identity theft, and cyber fraud. These risks may affect all citizens, including every member in this House, but particularly children and, in a lot of cases, women and elderly people. Those form part of the vulnerable groups. Government has therefore adopted a proactive approach to ensure that AI is developed and deployed in a safe, ethical, and responsible manner. This is why, in April 2026, my ministry launched an AI strategy for Mauritius, abbreviated AIM, together with the FAIR guidelines, FAIR, F-A-I-R, which constitute the national policy framework for AI governance. The FAIR guidelines are founded on principles like fairness, accountability, inclusiveness, and in as much as, Mr. Deputy Speaker, we talk about the integrity of people, now we also need to start talking about the integrity of algorithms, which constitute the functionality of AI, and responsibility, while also respecting, and very importantly, the fundamental rights of privacy and transparency, of privacy and freedom of speech, and ensuring transparency together with security of data. The implementation of the strategy, Mr. Deputy Speaker, extends to Rodrigues. So I'll just talk about what we're doing in Rodrigues for a couple of minutes, and that pertains to the second part of the second question, actually. I undertook an official visit to Rodrigues in May 2026, during which discussions were held with the commissioner responsible for IT and representatives of the Commission for Education and other officials from Rodrigues Regional Assembly. I'm pleased to inform the House and the honourable members representing Rodrigues that there are several collaborative projects that have been discussed. There are several agreements we've come to. The first coordination meeting was held yesterday, and there's one major initiative which is around Rodrigues IT Fair. So one of the things that we're doing is we've invited 2 students from Rodrigues to come in and participate in AI workshops so that they can prepare artifacts to be demonstrated during the IT Fair. But one very important element is the establishment of the Computer Emergency Response Team for Rodrigues and an AI coordination unit which will work in close collaboration with my ministry. My ministry will also provide technical assistance for the deployment of the correct app for Rodrigues. So the moment somebody who is registered as being from Rodrigues logs in, we will see the Rodrigues display in there, so it will be totally personalized. Coming back to the AIM strategy for Mauritius, we have undertaken it through a phased approach. And this strategy also provides for gradual establishment of AI governance mechanisms. The risks that we are facing, we are not the first one to face it. There are several other countries, Mr. Deputy Speaker, which have faced it. We know that the UK has gone the principles-based approach. There is no legislation per se, even though there was the introduction of a private member bill in the Parliament of the UK. But it doesn't seem like it will be successful. While the European Union, they've undertaken a risk-based approach. However, in Mauritius, what we've done, and this is what the FAIR guidelines are based on, we have actually taken a principles-based approach with the aim of ultimately giving legislative powers. So after discussion as well with the Attorney General, we believe that next year we will be starting to define the AI Act for Mauritius. And Mr. Deputy Speaker, sir, to conclude, I would just like to say that the FAIR guidelines are intended to serve as a foundation for future governance of AI in the Republic of Mauritius, including Rodrigues, obviously, of which all sectors that operate, whether it is education, it is trade, it is banking, financial services, they can all build their AI guidelines based on the current guidelines that we have. And when we are deploying, when we are developing the AI legislation, we will do so in coordination and collaboration with all the other regulatory authorities. Thank you, Mr. Deputy Speaker, sir.
Yes, you have a supplement.
Thank you, Mr. Deputy Speaker. Sir, can the Honourable Minister inform the House what steps the government is taking to ensure that the necessary regulatory framework and technical expertise are in place before the artificial intelligence becomes more widely deployed?
Yeah. Thank you, Honourable Member, for this supplementary question. AI is already widely deployed in Mauritius.
Just answer your question, please. Don't give us.
Yeah, but it is totally linked, Mr. Deputy Speaker.
Yes, come straight to the question.
He concluded his question with widely deployed. Now, the measures that we are taking. First, we have established the FAIR guidelines. We have as well the plan of giving it legislative powers. Secondly, we are running sensitization campaigns with different sections of the population. Thirdly, we have also undertaken training for staff within Mauritius for them to come up to speed so that they can actually develop applications and apps as well that are actually in compliance with the fair guidelines. And fourthly, we are relying as well on the G2G agreement with the Government of India for further advice on how to strengthen it. Thank you.
Ask for a specific question.
Yes.
Wide answers.
Yes, very specific this one. So how can the Honourable Minister inform the House as to how is the government going to engage with international partners to ensure that our approach to artificial intelligence regulation is aligned with global practices?
Thank you. So this one is very specific. To come to the response, when we developed the fair guidelines, we actually did it in line with what the SADC regional economic bloc is envisaging, what COMESA is envisaging, and as well as what the African Union is envisaging. So it's totally aligned. Plus, we had these fair guidelines validated by the UNDP as well as the United Nations teams. Therefore, we are currently, the approach that we have taken is actually based on international best practices.
Thank you. The Honourable First Member for Wakaforeal.
B938, s'il vous plaît.
Mr. Deputy Speaker, sir, the PQ contains several subparts, and each part will warrant that I provide ample details and information to the House. I will rely on your indulgence. Let me first of all point out that textbooks...
If your reply is long, circulate the answer, please.
Okay.
Circulate the answer.
Yes, I will do that.
Yes, you will have your supplementary, of course.
Dans son discours, durant les débats sur le budget, le ministre avait fait référence aux projecteurs et aux e-books qui sont utilisés en remplacement des manuels manquants. Mais le ministre est-il au courant que dans de nombreuses écoles, les projecteurs ne sont pas opérationnels? Et pourrait-il informer la Chambre qu'est-ce que son ministère a prévu pour les élèves qui n'ont pas accès à Internet et donc pas accès aux e-books?
Merci bien, l'honorable membre. Mr. Deputy Speaker, sir, in fact, as per my information from Directorate Primary, teachers and students are using tablets for that, and also all photocopies have already been supplied in the 4 zones of the country. And another query, Honourable Member rightly pointed out, that, and I assure her, that students are not going to be penalized because assessment are not based on books, for grade 1 especially. It is oral-based, activity-based. Thank you.
Yes.
L'honorable ministre peut-il informer la Chambre du coût de production et de distribution des fascicules photocopiés et sous quelle ligne budgétaire ces dépenses ont-elles été imputées?
Si on n'avait pas fait les photocopies, elle aurait me posé la question, pourquoi on n'a pas fait? On a cherché un moyen, on a fait. Maintenant, je dois vérifier. Je ne marche pas avec le chiffre en tête. Mais d'après moi, even then I can say, ça va coûter dans les alentours de 200 000 quelques. Ça, je peux le dire, pour 4 zones. Voilà, merci. I am ready to answer.
Si l'honorable ministre peut donner la garantie que dans toutes les écoles, tous les manuels nécessaires seront disponibles avant la rentrée 2027 pour permettre la bonne progression du programme et le bon suivi des élèves.
Merci, honorablement. Ma part, vous, nous tous ici, on est très soucieux que nos enfants reçoivent leur textbook on time. On a tout fait, monsieur le vice-président. Exception, c'est pour ce livre-là en particulier, pour ce grade-là. Presque à 95%, tous les enfants ont eu leur livre. Et je veux m'assurer qu'en 2027, ils reçoivent leur livre at the right time. Merci.
The Honourable Third Member for Port South, Port Central.
B939, please.
The Deputy Speaker, sir, the new version of the penalty point system became operational on Saturday, 31st January 2026, exactly on target, as announced in budget exercise 2025-2026 at paragraph 197. In light of the first 3-month report submitted to government on the performance of the penalty point system, which is a novelty I have introduced, adjustment has been brought to the range of points of one of the most problematic issues, that is use of handheld microphone or telephone handset while driving, which has been reviewed from the range of 3 to 6 to 5 to 10 points, effective from 10 June 2026. Any further adjustment to the penalty point system will be data-driven, implying that the overall system will evolve in a dynamic environment. Deputy Speaker, sir, to come to the substantive question from the honourable member, I have to point out that speed offences are monitored and detected through a network of 63 fixed photographic enforcement devices across the island, as well as by mobile handheld laser radars operated by the police at sites where speeding by motorists is a common feature. The law provides for distinct tier of speed ranges and offences, each carrying different financial penalties. Where applicable, corresponding penalty points are also applied, namely, firstly, exceeding the speed limit by not more than 15 kilometers per hour attracts a fixed penalty of 2,500 rupees, but does not incur any penalty point. 2, exceeding the speed limit by more than 15 kilometers per hour, but not more than 25 kilometers per hour, attracts a fine of 5,000 rupees and incurs 2 to 4 penalty points. And 3, exceeding the speed limit by more than 25 kilometers per hour, attracts a fine of 10,000 rupees and incurs 4 to 6 penalty points. Deputy Speaker, sir, according to records, 16,128 contraventions have been established by the police for speeding offences since the reintroduction of the penalty point system on 31st January 2026 up to 25th of June 2026 as follows. Not more than 15 kilometers per hour, 10,073 contraventions. More than 15 kilometers per hour, but not more than 25 kilometers per hour, 5,205 contraventions. Not more than 25 kilometers per hour, 850 contraventions. Deputy Speaker, sir, I personally take serious note of the number of contraventions for the offence of speeding. I also note that the significant rise in the number of contraventions established in relation to the offence of speeding by over 15 kilometers per hour, but not more than 25 kilometers per hour, which was 3,429 as of 30th of April 2026, stood at 5,005 as at 25 June 2026, representing an increase of almost 52%. In regard to the offence of speeding by more than 25 kilometers per hour, records reveal a similar trend. Accordingly, 554 contraventions were established by 30th of April 2026, while latest figures from the police indicate an increase of over 53% in respect of that offence. Deputy Speaker, sir, as I stated, in light of its evolution, a decision will be taken at the level of government in respect to any offence requiring adjustment to the penalty point system in due course. And I take the opportunity to reassure the House that I will make no compromise in relation to road safety measures. I note the uproar among members of the public claiming that government has been overly strict on the issue of mobile phones usage behind the wheel, but allow me to point out that over 500 driving licenses have recently been revoked in Western France using mobile phones while operating a vehicle. It is certainly food for thought for anyone questioning our commitment to road safety. Deputy Speaker, sir, before I conclude, I wish to thank the Honourable Prime Minister and Minister of Finance for the provision made in Annex to the Budget 2026-2027 in regard to the amendment to be brought to the Road Traffic Act to enable the use of safe city cameras to detect traffic offences, which includes speeding, and to give the Traffic Management and Road Safety Unit legal status at long last as the national lead agency responsible for effective management and road safety. The TRMSU will thus become the distinct legal personality, a status it was devoid of during decades of its existence. Thank you.
Yes, Honourable Omia.
Thank you, Mr. Deputy Speaker, and my colleague Minister in my constituency. Recent figures published recently by the independent media show that there is no abating in the number of fatalities and road accidents in the country. May I ask the Honourable Minister whether abating, it's not coming down. May I ask the Honourable Minister whether his ministry has established any, my friend KPI is here, any key performance indicators to evaluate the success of this penalty point system, and if so, what are they, and have they been met?
Like I said, Deputy Speaker, sir, we have not established a static system. It is a dynamic system that will be revised every semester in order to make the law become more strict and to inculcate the fear factor within the driver community. But I must say that the KPI is being, like I said, is being sent to Cabinet every semester, and we will adjust accordingly. But one thing for sure, no matter how good a policy is, no matter how good a piece of legislation is from the road traffic perspective, the success of its implementation will depend on the police, insofar as enforcement is concerned. Yesterday, since the Honourable Member has...
I think you have answered the question. Okay. Next, you have a supplementary.
Thank you, Mr. Deputy Speaker. My colleague, I know he's very keen to make sure that there is success in this process. However, I wish to ask the Honourable Minister whether the government or his ministry has considered integrating driver rehabilitation courses, behavioral training, or defensive programs for motorists approaching the penalty point threshold.
Yes. Deputy Speaker, sir, it is in the law. When approaching the 12 points, the 10 points, there is a rehabilitation that allows a driver to, not to lose their license.
Thank you. The Honourable Third Member for Port Restores, Port Idle.
B940. Thank you.
Deputy Speaker, sir, may I first thank the Honourable Member for his question. Deputy Speaker, sir, I wish to inform the House that my ministry is responsible for the processing and prescription of all schemes of service for posts in civil service, including those of Rodrigues Regional Assembly. Once a scheme of service is approved by the Public Service Commission and prescribed by my ministry, it is uploaded on the scheme of service portal of my ministry. The scheme of service portal has been launched as part of the broader civil service digital transformation program. These schemes of service are the foundation for recruitment and promotion in the public service. There are presently 2,509 schemes of service on the scheme of service portal of my ministry. Deputy Speaker, sir, with regard to Part A of the question, I wish to inform the House that in year 2025, after I joined the ministry, my ministry carried out an assessment exercise with a view to reviewing the contents of the scheme of service web page. The exercise revealed that there were schemes of service for posts that had been abolished, for which date as far as back as 20 years ago, which still appeared on the website. However, consultations are being held, and it is necessary, with ministries and departments to ascertain whether these schemes of service are still valid and as to whether there are officers serving in these posts. This exercise is also taking into consideration all the changes in appellation of posts which have been recommended in the Pay Research Bureau reports and which have been reflected in the Civil Service Establishment Order. The exercise is expected to be completed by the end of this year, at the earliest November of this year, following which the scheme of service website will be up to date. However, it is to be noted that our scheme of service are subject to constant review. The updating of the website is an ongoing process. Deputy Speaker, sir, I also wish to inform the House that a collaborative platform and document management system, the E-Scheme of Service, for short, ESOS, has been developed by my ministry to digitalize the processing and prescription of schemes of service. The ISOS will replace manual handling with a digital workflow for all review of scheme of service and aims to eliminate processing delays. My ministry is proceeding with the user acceptance testing, and the ISOS will subsequently be rolled out in all ministries and departments by the end of this very year. With the implementation of the ISOS, the discrepancies in the schemes of service database will no longer arise. As regards Part B, Deputy Speaker, sir, of the question, I wish to inform the House that there are 118 parastatal organizations which presently fall under the purview of the PRB, the Peer Research Bureau. As the House is aware, currently the final approval of schemes of service for posts in parastatal organizations rests with the respective boards. Once a scheme of service is approved, a copy thereof is submitted to the parent ministry only for record purposes. Consequently, prior to PRB 2026, my ministry was not involved in the processing of schemes of service for posts in parastatal organizations and local authorities, except when the PRB was to be consulted on the salary grading of new posts. As regards the scheme of service for posts in local authorities, they are examined at the level of the Unified Local Government Service Board before being submitted to the Local Government Service Commission for approval. Deputy Speaker, sir, however, I am now informed that the Peer Research Bureau has, at paragraph 16 of its report of 2026, observed that schemes of service of a few grades in certain parastatal bodies falling under its purview has been significantly amended without seeking the prior advice of the Bureau on any bearing on salary. The Bureau considers that this practice is inappropriate as the changes brought to the schemes of service are not according to set policies. The Peer Research Bureau has, therefore, recommended that henceforth proposed schemes of service of parastatal bodies and local authorities should be first submitted to the respective parent ministries for examination, then to my ministry for consideration to ensure consistency and uniformity and to avoid any malpractice. I also wish to inform the House, Deputy Speaker, sir, that the websites of ministries and departments form part of the official Government of Mauritius domain, and posting of schemes of service in respect of parastatal bodies and local authorities on websites of ministries and departments requires a policy decision that leads to consultations with relevant authorities such as the Prime Minister's Office, the GIS, and the AG Office. Thank you. Deputy Speaker, sir.
The Honourable First Member for Portrush North and Mort Island.
Question B 941.
Mr. Deputy Speaker, sir, I will be very brief. Yes, yes, I have taken cognizance of the apprehension, and yes, there will be consultations with the stakeholders. Thank you.
Yes, Honourable Member.
Quand même deux questions. Merci, Monsieur le Vice-président. L'honorable ministre, est-il au courant qu'il y a des craintes de fermeture des écoles maternelles en raison des faibles salaires proposés et du cumul de fonctions administratives? Est-ce que cela sera revu? Merci.
Mr. Deputy Speaker, sir, yes, I have received representation from CTSP, all right, the President, whereby they discuss these issues. I will be meeting them in due course and other stakeholders to discuss them. Yes.
Thank you. The Honourable Third Member for Grand Poutodo.
B 942, s'il vous plaît.
Monsieur le Vice-président, les raisons de l'approvisionnement irrégulier en eau dans les régions de Pointe-aux-Calonniers, Grand B et Cap-Malheureux sont les suivantes. D'abord, la présence des tuyaux défectueux dans les régions sujettes aux ruptures, entraînant une baisse de pression ou une absence d'approvisionnement en eau, notamment dans les zones de haute altitude. Ressources en eau insuffisantes, entraînant des heures d'approvisionnement intermittentes, les réservoirs de service vieillissants de Rouge-Terre, Mont-Loisier-Rouillard, le réservoir d'équilibrage de poudre d'or ont des capacités de stockage faibles, insuffisantes pour répondre à la demande actuelle. Le niveau d'eau des surfaces et souterraines réduit pendant la saison difficile. Afin d'améliorer l'approvisionnement en eau dans la zone d'approvisionnement, le Nord en général, la CWA envisage la réalisation des projets suivants: le remplacement de tuyaux entre Plaine des Papayes et le réservoir de Rouge-Terre. Ce projet permettra d'accroître la capacité de prélèvement d'eau et d'optimiser l'utilisation d'un système de CPF du réservoir de Plaine des Papayes. Il y a eu 30 millions de roupies dans le dernier budget, le budget qu'on discute actuellement. Donc 30 millions de roupies dans le budget a été alloué. B, il y a l'amélioration du réservoir de service de Mont-Loisier-Rouillard, dont la capacité passera de 2700 m3 à 4000 m3. Ce projet permettra d'accroître la capacité de stockage et d'améliorer l'approvisionnement en eau dans la circonscription numéro 6. La préparation du dossier d'appel d'offres pour les études géotechniques est en cours. Le lancement est pour juillet 2026, donc ce mois-ci. Ensuite, il y a la réhabilitation et la modernisation du réservoir d'équilibrage de poudre d'or, qui est actuellement en cours d'évaluation au CBB. Ce sera qui va commencer en novembre 2026, cette année-ci. Ensuite, il y a la modernisation du pipeline existant. C'est un gros projet. Le pipeline existant à Grand B, sous-dimensionné, sera modernisé le long de la route principale de chemin 20 pieds. C'est un très gros projet. Et aux alentours, sur une longueur de 4,5 km. Tout au long du chemin 20 pieds, ce projet sera mis en œuvre dans le cadre de la ligne de crédit indienne, le Line of Credit indien. Phase 2 est actuellement en phase de conception. L'attribution provisoire du contrat est prévue pour décembre cette année-ci et les travaux étant attendus en janvier 2027, donc au début de l'année prochaine. Ensuite, nous avons la réhabilitation et extension de la station d'épuration des eaux de la Nicolière, sortant de 66 000 m3 à 130 000 m3. Mais la CWA a sollicité et attend l'approbation du gouvernement mauricien pour passer à la phase 2 du projet. Ensuite, nous avons le projet de dessalement. Le dessalement fait partie du plan Marshall, élaboré par mon ministère pour mobiliser des ressources en eau supplémentaires afin d'améliorer l'approvisionnement en eau dans le Nord en général. Nous pensons ici à une usine de dessalement à grande échelle entre 10 000 et 50 000 m3 par jour. Un appel d'offres a été lancé en mai 2026 auprès de 4 soumissionnaires sélectionnés et qui devaient déposer leur offre d'ici juillet 2026, donc le mois prochain. Donc le consultant va être nommé pour cette étude pour le dessalement. Nous examinons aussi 3 projets, je vais terminer, Monsieur le Vice-président, nous examinons aussi 3 projets. Il y a un projet à Pointe-aux-Calonniers, renouvellement du réseau de distribution. Nous avons un projet à Cap-Malheureux, renouvellement du service main, le gros tuyau pour être changé, rénovation du pipeline entre Upperville et Cap-Malheureux sur un tronçon de 5,1 km. Ce projet, c'est donc 2. Troisième, c'est Grand B la Salette, rénovation du tuyau principal de sortie du réservoir. Mais ces 3 projets, donc Pointe-aux-Calonniers, Cap-Malheureux et Grand B la Salette, ces projets sont soumis à la disponibilité des fonds. Donc nous avons demandé des fonds au ministère des Finances et nous attendons l'approbation du ministère des Finances pour aller de l'avant avec ces 3 projets qui concernent votre circonscription. Merci.
Honorable First Member for Waqf-L'Oréal.
P 943, s'il vous plaît.
Mr. Deputy Speaker, sir. In January 2025, government set up an interministerial committee on work permit issues under my chairmanship and comprising of the Minister of Tourism, the Minister of Social Integration, Social Security and National Solidarity, the Minister of Industry, SME and Cooperative, to look into the difficulties being encountered by private companies in obtaining work and residence permits, and to come up with recommendations. It was also agreed that the Minister of Information Technology, Communication and Innovation would be roped in the committee. The Inter-Ministerial Committee met on several occasions and finalized its report and made 76 recommendations which were approved by government on the 5th of September 2025. Mr. Deputy Speaker, sir, as regard to part A of the question, I'm informed that more than two-thirds of the recommendations have already been implemented, and the implementation of the remaining recommendations are ongoing. I am tabling the information on the status of each of the 76 recommendations made by the committee, as well as the date in which they came into effect or are expected to come into effect. Mr. Deputy Speaker, sir, with regards to Part B, Roman I of the question, as can be seen from the information table, some of the recommendations have not yet been fully implemented, mainly for the following reason. Firstly, there have been delays in the implementation of the rules-based work permit system, as I mentioned in answer to the private notice question of 24th of June 2026, because the tender exercise was not successful. I am informed that a fresh tender exercise has already been launched on the 12th of June 2026. Secondly, the implementation of several recommendations require legislative amendment and modification to the standard contract of employment of migrant workers, for which the Attorney General's Office and other stakeholders are being consulted. And thirdly, the implementation of certain recommendations fall under the Passport and Immigration Office, the Economic Development Board, and other ministries which are outside the control of my ministry. As regards Part B, Roman II of the question, the recommendations not yet fully implemented are expected to be completed progressively during the financial year 2026-2027, and my ministry is following up closely with the concerned authorities. Mr. Deputy Speaker, sir, with regard to Part C of the question, the monitoring committee agreed by government in September 2025 has already been set up at the level of our ministry under the chair of the permanent secretary and comprise representatives of the Prime Minister's Office, the Passport and Immigration Office, and the Economic Development Board. It was also agreed that the representative of other ministries, departments, and organizations would be roped in and as and when required. I am informed that the monitoring committee met in December 2025 and took note of progress achieved in the implementation of the recommendation. I am further informed that several subcommittees were set up to review the work permit fees, to review the enhancements to be brought to the National Electronic Licensing System, and on amendments to be brought to the Labour, Occupation, Safety and Health and other legislation. Each subcommittee has met on several occasions. With respect to the rules-based work permit system, a steering committee is being chaired by the Secretary for Home Affairs, and as already stated, EDB has on 12th of June 2026 launched a fresh tender exercise.
Yes, honorable member.
Je vous remercie. Je n'ai pas encore eu accès aux informations, j'ai pas encore eu l'occasion de voir les informations qui ont été déposées sur la table de l'Assemblée, mais permettez-moi de faire référence aux recommandations 40 et 41, le statut provisoire de victime. J'aimerais savoir si le ministre peut confirmer si ces dispositions permettant à un travailleur migrant victime d'exploitation d'obtenir un permis spécial ou un transfert vers un autre employeur pendant le traitement de sa plainte, est-ce que ces dispositions sont opérationnelles? Et dans la négative, peut-il informer la Chambre combien de travailleurs sont concernés et dans l'attente de l'implémentation de ces mesures, étant donné que, à ma connaissance, jusqu'à 2 ans d'attente, il y a des travailleurs victimes d'exploitation qui sont encore en train d'attendre 2 ans après qu'ils ont déposé leur plainte et qui se retrouvent malheureusement dans l'illégalité alors qu'ils sont victimes.
Mr. Deputy Speaker, sir, from the document table, you will see that under recommendation 40, The status is ongoing and applications are considered on a case-by-case basis. But I need to point out, Mr. Deputy Speaker, sir, that my ministry is only concerned with work permit. So once, a work permit has been terminated, the residence permit of the migrant worker automatically terminates and he becomes an illegal migrant. And therefore, it is to the discretion of the PIO, the Passport Immigration Office, whether to extend the delay of the residence permit or not.
Il n'est pas question d'étendre, il est question de leur donner un permis spécial pour pouvoir
Pose your question.
D'accord. Mais j'aimerais savoir si ce n'est pas son ministère qui s'occupe des cas des travailleurs victimes d'exploitation, quelles mesures il préconise pour cela, et est-ce qu'il reconnaît que l'absence d'implémentation des recommandations crée une situation où des travailleurs victimes se retrouvent dans l'illégalité?
Yes. Mr. Deputy Speaker, so my ministry is responsible for looking after migrant workers who have been subject to breaches of Workers' Rights Act. There is a special migrant unit that is devoted to treating those applications. Now, the problem in practice that we have is once the employment is terminated, what happened to these migrant workers? Who pay for their accommodation? Who pay for their food and water? If there is a request for a transfer, this is entertained by my ministry on a case-by-case basis. Otherwise, the worker has to go back to his country. He can come back to Mauritius when his case is heard, or he can give a proxy, a power of attorney for someone, including someone from my ministry, to represent him in his court case.
Répondre à la question. Je ne parle pas,
je
ne parle pas du cas où le contrat est terminé. Je parle du cas où il y a des plaintes, où les travailleurs sont victimes. Il parle du Migrant Unit. Est-ce qu'il compte faire quelque chose pour que le Migrant Unit puisse traiter plus rapidement ces plaintes et grossir l'effectif de son Migrant Unit, alors que de l'autre côté, le unit qui est responsable de délivrer les permis, ils sont beaucoup plus nombreux dans ce unit-là. Donc clairement, ce sont les employeurs qui sont protégés au détriment des employés victimes d'exploitation.
What is your question?
Qu'est-ce qu'il compte faire pour que le Migrant Unit considère plus rapidement les plaintes et est-ce qu'il compte grossir l'effectif de son Migrant Unit?
Migrant Unit is heavily staffed already. And the Honourable First Member does not realize that when there is a dispute, most of the time it results in the termination of the employment because the worker does not resume employment because he has been ill-treated or because of a dispute. So at the level of our ministry, our priority is to ensure that the workers get its right. But when there is a dispute, when the employer is not agreeable to the version of the worker, then the case has to proceed to court. So when in this case, what happened to the migrant worker? If he stays in Mauritius, who will pay for his accommodation? Who will pay for his food and beverage? That is why, unless we have a new employer who is willing to transfer and take charge of that employee has to go back to his country.
Okay, we've done enough on this point. The Honourable Third Member for Flack and Bonacay.
Mr. Deputy Speaker, sir, B944.
Mr. Deputy Speaker, sir, there are two Cambridge International exams which are conducted yearly in Mauritius, namely the School Certificate and the Higher School Certificate. The SC results for academic year 2025 were proclaimed on 15 January. Out of a total of 11,735 candidates, 8,130 were successful. As for HSC, the results for academic year 2025, out of 5,794, 4,576 were successful, representing a pass rate of 78.98% for the Republic. With regard to Part A of the question, I will refer the Honourable Member to my reply to PQ B99 on the sitting of 24th March 2026 regarding the reform in the education sector. As regards Part B of the question, there is a quality assurance and inspection division, both within my ministry and at the level of the private secondary education authority to provide feedback on the academic performance of the schools. The QAID conducts an QAID subject monitoring of speaker, sir, which is part of our ongoing strategy to enhance the educational sector at secondary level. Thank you.
Yes. The Honourable First Member for Montaille-Blanche, Grand Rivière South, please.
Thank you, Mr. Deputy Speaker, sir. B 945.
Mr. Deputy Speaker, sir, I'm informed that time-off facilities to executive members of UPSI are presently being granted in line with the PSEA's Circular number 116 of 2017, dated 20th July 2017. I am tabling a copy of the circular. In June 2025, UPSI requested the PSEA to extend time-off facilities to executive members of UPSI Rodrigues branch. The matter was concurrently referred to the Conciliation and Mediation section of the Ministry of Labour and Industrial Relations. In this respect, the PSEA sought legal advice from the Attorney General's office as to whether managers of private secondary schools and unions should be requested to comply with the Employment Relations Act in all matters relating to the granting of time-off facilities. I am informed that the Attorney General's office has advised that in line with Section 16(4)(b) of the Private Secondary Education Act, secondary and pre-vocational schools remain the employer of staff of private secondary schools. Accordingly, requests for time-off facilities made by officers of trade unions representing employees of the private secondary schools would fall to be considered by the employer concerned in accordance with the provisions of the Employment Relations Act. The board of the PSEA complied with the legal advice and decided that the provision of the circular number 116 of 2017 would no longer be applicable as from 2027. Consequently, requests for time-off facilities made by representatives of trade unions representing employees from the private secondary schools should be considered by the employer, subject to the exigencies of service and provided that the smooth operation of the workplace is not impaired. In view thereof, the director of the PSEA issued a circular on 26 May 2026 informing all private secondary schools of this decision. I am also tabling a copy of the circular. I'm also informed that executive members of the Union of Private Secondary Education Employees should carry on with their responsibilities without any impediment, and the time-off facilities are at the discretion of the rector of the private school. Thank you.
The Honourable First Member for Montaille-Blanche, US House, please.
Thank you, Mr. Deputy Speaker. Sir, B 946.
Mr. Deputy Speaker, the proposed G2G arrangement with the Government of India provides Mauritius with several strategic, economic and energy security advantages, namely A. Enhanced energy security, B. Strengthening bilateral relations, C. Greater supply stability during global crises, D. Improved payment flexibility, E. Long-term procurement predictability, F. Potential preferential treatment, and G. Technical cooperation and capacity building. Under the government-to-government agreement, the State Trading Corporation and the Indian Oil Corporation Limited have been designated as the authorized agencies to negotiate and conclude the full framework which will serve as the basis for the long-term supply agreement. I am informed that the State Trading Corporation, SCC, initiated discussion with IOCL early this year for a long-term supply arrangement of petroleum products for an initial period of 5 years, with provisions for renewal and/or termination. Mr. Deputy Speaker, sir, I wish to point out that several meetings have been held to negotiate the different aspects of the agreement, amongst which the specifications, pricing, premium, payment terms, and currency, contamination liability provisions, quantity tolerances, and other contractual and legal considerations, amongst others. Mr. Deputy Speaker, sir, the preparation of a framework agreement is not an easy task, given the high uncertainty due to the geopolitical situation and the global oil market passing through unprecedented volatile phase. There was originally uncertainty in outlook of oil prices and availability. The problem was further compounded by the fact that even shipping rates had substantially gone up, and there was no visibility of shipping freight in near and mid-term. Hence, with a view to come up with a scenario that would match our expectations, we had to wait for some time till the international market stabilizes and the price volatility normalizes. As at date, negotiations have largely progressed, and it is expected that by end of July, the parties would be able to finalize the agreement. Mr. Deputy Speaker, sir, the honourable member would agree that once a government has committed itself towards another government, it would not be appropriate nor ethical to engage in negotiations with alternative suppliers of petroleum products. Notwithstanding this, necessary arrangements have been made to meet the country's energy needs pending finalization of the agreement. Thank you.
The Honourable Third Member for Vieux-Grand-Port, Rosebel.
Thank you, Mr. Deputy Speaker. PQ B947, please.
Mr. Deputy Speaker, sir. With your permission, I will reply to parliamentary question B947. Mr. Deputy Speaker, sir, medical practitioners are employed on yearly renewable contract and remunerated on seasonal basis to serve the ministry, the medical unit of my ministry. They are responsible, amongst others, to conduct domiciliary visits to elderly persons and serve in medical boards for disability assessment. My ministry presently employs 332 such medical practitioners whose offer of employment are renewed on a yearly basis. With regard to Part A of the question, I'm informed that medical practitioners whose services applied to be retained by my ministry, by the Ministry of Social Integration, Social Security and National Solidarity on a contractual basis, should be fully registered as medical practitioners in accordance with legislation in force in Mauritius. Our ministry applies the same principle in advertising and recruitment as for the post as the Ministry of Health does. I am informed that the Ministry of Health and Wellness that all doctors practicing modern or conventional medicine in the Republic of Mauritius require a registration with the Medical Council of Mauritius under the relevant provisions made in the Medical Council Act 1999 as amended. I am further informed that general practitioners are registered as such after passing the medical registration examination under Section 22(1)(ca) of the Medical Council Act. Mr. Deputy Speaker, sir, in regards to Part B of the question, the Ministry of Health and Wellness has confirmed that medical practitioners serving at my ministry are all registered as general practitioners and have obviously been successful in the medical registration examination set by the Medical Council of Mauritius. Mr. Deputy Speaker, let me inform the Honourable Member and the House that the recruitment of medical practitioners on contractual basis started in August 2009. The last recruitment exercise was carried out in March 2020 and the PSC has approved the recruitment of 250 medical practitioners. As from 2020, medical practitioners on contractual basis have been recruited and have been given employment for a duration of 1 year, which have been subsequently renewed. Last month, I renewed their contract of employment for a further period of 1 year. Detail of their employment is being discussed in the context of the disability reform of my ministry and the government. Thank you, Mr. Speaker, sir.
Yes, one supplementary because we are already out of time.
Mr. Deputy Speaker, can the Honourable Minister state whether the doctors sitting on the medical boards, whether they have the requisite speciality in accordance with the disease for which the patient has applied for a pension? For example, a specialist in cancer sitting on a board assessing a patient who has cancer, for example?
I responded to this query in the last session, but I would state that in the medical board, these are medical practitioners. Some of them might be specialists, but it is a requirement under law for the medical tribunal that the doctors sitting on the medical tribunal, they are the respective specialists of the case being assessed.
Time is over. The table has been advised that the following PQs have been withdrawn. B960, 954, 957, 952, 958, 949.
Motion.
Mr. Deputy Speaker, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded by the BPM. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye. Those against say no. The ayes have it.
Statement by Minister.
Mr. Deputy Speaker, with your permission, I wish to make a statement to the House regarding shooting, fishing, ecotourism leases granted by the Ministry of Agro-Industry, Food Security, Blue Economy and Fisheries. Now, state forest land, terrain chassé, are leased for shooting and fishing and ecotourism purposes in accordance with Shooting and Fishing Lease Act. The grant of the lease does not give the right of ownership of the land, which remains with government. Mr. Deputy Speaker, I'm informed that there are presently some malicious posts on social media wherein state forest lands are allegedly being put on sale to the public. I wish to reassure the House that as per Section 5 of the Shooting and Fishing Leases Act, lessees of this land cannot assign or sublet the whole or any part of the interest in the lease without prior written consent of government. Additionally, Mr. Deputy Speaker, pursuant to Section 11 of the Shooting and Fishing Leases Act, leased state forest land remain in the ownership of government, hence no lessee have the right to put any leased state forest lands on sale. The Ministry has already reported the matter to the Mauritius Police Force for an investigation. My Ministry will take prompt remedial action in case of any breach of condition of lease by lessees.
Big bills, first reading.
Honourable Attorney General.
First reading.
Mr. Deputy Speaker, sir, I move that the Criminal Code Amendment Bill number 10 of 2026 be read a first time.
Seconded. Seconded.
Big bill, third reading.
Mr. Deputy Speaker, I move that the Appropriation Bill 2026-2027, Bill number 9 of 2026, be read a third time and passed.
Seconded. BPM. The question is that the Appropriation 2026-2027 Bill number 9 of 2026 be read the third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it. Madam Speaker, we resume the seat.
big bill, second reading.
Yes, Honourable Minister.
Madam Speaker, I move that the Domestic Abuse Bill, number 8 of 2026, be read a second time. Madam Speaker, for every victim whose voice was silenced by domestic violence, to those who tragically lost their lives, this Domestic Abuse Bill stands as a living memorial. This new legislation is a pledge that their suffering will not be forgotten, and that this House, through this bill, will transform pain into protection, silence into justice, and despair into hope. It is a declaration by this government that the dignity, safety, and well-being of every person within the walls of their home is a matter of national concern. Madame la Présidente, je ne peux m'empêcher cet après-midi de penser à toutes celles qui n'ont pas survécu, à Sneha, à Vanessa, à toutes ces femmes dont les noms sont gravés dans nos mémoires et dans les registres de nos tribunaux. Je voudrais dire à leurs familles et à leurs proches que ce texte de loi nous donne aujourd'hui les outils pour mieux protéger les femmes, les victimes. Il est de notre devoir, et cela doit être aussi un engagement collectif, que plus jamais une femme ne soit conduite à la mort par celui qui prétendait l'aimer, alors même qu'il y avait déjà eu des signes d'alerte dans bien des cas. Madame la Présidente, la loi sur la protection contre les violences domestiques a été promulguée en 1997 avec pour objectif principal de protéger les conjoints contre les actes de violence. Elle a été amendée en 4 occasions, notamment en 2004, 2007, 2011 et 2016, afin d'élargir son champ d'application et de renforcer les mesures de protection offertes aux victimes. Malgré ces amendements, les violences domestiques continuent de constituer une préoccupation sociale majeure, encore plus aujourd'hui. L'émergence de formes d'abus nouvelles et de plus en plus complexes, notamment les violences émotionnelles, psychologiques, économiques et celles facilitées par la technologie, a mis en évidence les limites du cadre législatif existant. Madame la Présidente, permettez-moi de corriger une idée reçue et très répandue dans notre société, celle selon laquelle cette législation... Ce n'est pas exact. Les données les plus récentes des Family Support Service de mon ministère le démontrent clairement. En 2023, un total de 7177 cas de violences domestiques ont été signalés, dont 5729 victimes féminines et 1448 victimes masculines. En 2024, un total de 5758 cas ont été signalés, dont 4988 victimes féminines et 770 victimes masculines. En 2025, ce chiffre a grimpé fortement à 7562 cas, avec 6478 victimes féminines et 1084 victimes masculines. Et pour la période de janvier à mai 2026, soit seulement 5 mois, 3049 cas ont été signalés à mon ministère, dont 2674 femmes et 375 hommes. La tendance concernant les abus physiques et psychologiques n'est pas à la baisse, et ce fléau touche de plus en plus la gente masculine aussi. Il exige une réponse législative à la hauteur de sa gravité. En ce qui concerne les Protection Orders, il y a eu une situation actuelle qui s'avère inquiétante. Les victimes qui retirent leur demande de protection. En 2023, sur 811 demandes, 216 ont été retirées. En 2024, sur 783 demandes, 199 ont été retirées. En 2025, sur 986 demandes, 221 ont été retirées. Et de janvier à mai 2026, sur 477 demandes, 95 ont déjà été retirées. Lorsqu'une victime retire une demande d'ordonnance de protection, c'est rarement parce que le danger s'est dissipé. C'est souvent parce que la peur, la dépendance financière, la pression sociale ou la perte de confiance dans le système l'a réduite au silence une fois de plus. Les victimes qui retirent leur dossier ne mesurent parfois pas le danger qui les attend. Je me permets de citer 2 cas qui illustrent tragiquement cette réalité. Madame YB avait déposé une demande d'ordonnance de protection le 21 août 2025. Le 25 septembre 2025, elle a retiré son dossier et est retournée au domicile conjugal. En février 2026, il a été rapporté qu'elle avait quitté le domicile conjugal et à ce jour, elle demeure introuvable. Un autre cas qui m'interpelle, feu Madame NC, avait déposé une demande de protection order le 29 avril 2025. Elle a ensuite informé le tribunal qu'elle s'était réconciliée avec son mari et son dossier a été classé. Après son retour au domicile conjugal, en octobre 2025, elle a été tuée par son mari. Madame la Présidente, ces tragédies soulignent la nécessité de mesures préventives renforcées, d'une meilleure coordination interagences et de mécanismes de protection des victimes plus efficaces. C'est pourquoi ce texte de loi prévoit que lorsqu'une victime, après avoir déposé une demande de protection order, souhaite retirer son dossier, l'affaire sera transmise par la police au bureau du DPP. Et c'est au bureau du DPP de décider de la marche à suivre. Le DPP pourra alors demander aux officiers de mon ministère d'ouvrir une enquête afin d'éclairer la décision. Madame la Présidente, lorsque j'ai annoncé l'introduction du Domestic Abuse Bill, mon ministère, moi-même, nous avons reçu une représentation sur le choix des mots. Remplacer le terme d'abus par le mot violence. Permettez-moi de clarifier ce choix. Le terme violence évoque presque instinctivement le contact physique, le coup, la blessure, la marque visible. Et c'est précisément ce que ce texte vient corriger, cette réduction. Une femme dont le mari contrôle chaque roupie de son salaire ne porte pas de bleu. Une victime de harcèlement psychologique quotidien ne présente aucune blessure photographiable. Un homme humilié et isolé par sa partenaire devant ses enfants a un médecin légiste. Si le titre de la loi est encore Domestic Violence Bill, elle envoie malgré elle un message « Cherchez la blessure physique ». Et les victimes d'abus émotionnels, économiques ou virtuels continuent de se demander si ce qu'elles vivent compte vraiment. En définissant explicitement les violences émotionnelles et psychologiques dans le cadre légal, nous envoyons un signal fort. Ces formes d'abus doivent être traitées avec le même sérieux que la violence physique en raison des préjudices considérables qu'elles infligent. L'intimidation, la dégradation verbale, la manipulation peuvent avoir des effets graves et durables sur la santé mentale. Plus tôt les victimes le reconnaissent, plus tôt elles pourront chercher de l'aide. Madame la Présidente, il est important de mettre l'emphase justement sur cette forme de violence qui est financière. Les informations recueillies auprès des Family Support Services de mon ministère révèlent qu'un nombre significatif de victimes ne réalisaient pas qu'elles étaient sous l'emprise et le contrôle de leur conjoint. En raison de la confiance accordée à l'autre personne, elles ne percevaient pas que leur conjoint restreignait l'accès aux comptes bancaires, contrôlait les finances du foyer, les empêchait de travailler, accumuler des dettes en leur nom ou limiter leur indépendance financière. C'est souvent lorsqu'elles se retrouvent sans ressources et totalement isolées de leur cercle de soutien qu'elles cherchent de l'aide. Je voudrais évoquer le cas d'une jeune femme exerçant comme professeure dans un lycée. Celle-ci, en plus de son salaire, possédait un véhicule personnel. Pourtant, elle ne pouvait pas jouir des fruits de son travail. Son bourreau l'empêchait d'utiliser sa voiture et lui refusait l'accès à ses finances. Elle a finalement trouvé refuge dans un des foyers gérés par une ONG. Il faut savoir que les violences économiques ne touchent pas un segment particulier de la société. Elles affectent tous les milieux socio-professionnels. Madame la Présidente, au-delà de l'élargissement de la définition de l'abus domestique, les victimes doivent avoir accès à de meilleurs services de soutien, capables de répondre à leurs besoins immédiats et à long terme. Hébergement sécurisé, services spécialisés, accompagnement psychologique, aide juridique et soutien pratique pour les aider à reconstruire leur vie. Quitter une relation abusive est souvent un processus complexe et difficile qui requiert un accompagnement soutenu plutôt qu'une intervention ponctuelle. C'est dans cet esprit que depuis août 2025, j'ai renforcé le dispositif de soutien au sein de nos 12 Family Support Services offrant des services holistiques aux victimes, accompagnement psychologique, conseil juridique et représentation judiciaire, aide à la rédaction de déclarations sous serment et soutien psychosocial continu. Je tiens à exprimer ma sincère gratitude aux ONG qui fournissent un hébergement aux victimes de violences domestiques et à leurs enfants. Leur rôle est tout aussi important que celui de nos services. À la suite des consultations menées sur ce texte de loi, certaines ONG gestionnaires de shelters nous ont informés que très souvent, lorsqu'une victime devait quitter le domicile conjugal pour être admise dans leur structure avec ses enfants, elle n'avait pratiquement rien. Pas de vêtements, pas de cartable pour les enfants, pas de médicaments. C'est dans ce contexte que le Fonds de solidarité nationale, relevant du ministère de l'Intégration sociale, de la Sécurité sociale et de la Solidarité nationale, a mis en place un dispositif en faveur des victimes de violences domestiques. Une allocation leur sera accordée pendant les 2 premiers mois de séjour dans un abri. Cette aide permettra aux victimes d'accéder à leurs besoins essentiels grâce à l'allocation qu'elles percevront. Madame la Présidente, je tiens à rappeler aux membres de cette Chambre qu'en 2004, en ma qualité de ministre des Droits de la Femme, du Développement de l'Enfant et du Bien-être de la Famille, j'avais introduit le premier amendement à la loi existante afin d'y inclure toute personne résidant sous le même toit, lui donnant ainsi droit à la protection. Dans ce nouveau texte de loi, je vais au-delà des personnes résidant sous le même toit pour inclure tout acte commis par une personne à l'encontre de son conjoint, d'un enfant de son conjoint ou d'autres personnes avec lesquelles elle entretient une relation. Si nous ne prenons pas en compte la relation d'interdépendance entre adultes dans la nouvelle loi, nous manquerons à notre devoir d'agir dans le meilleur intérêt des victimes. The Domestic Abuse Bill définit comme membre de la famille toute personne résidant avec une autre personne et ayant la garde et la charge de celle-ci en vertu d'une décision de justice. Madame la Présidente, nos tribunaux eux-mêmes ont su donner voix à la gravité de ces crimes. Dans l'affaire de State against Nabi Bacchus de 2025, la Cour suprême de Maurice s'est retrouvée confrontée à une affaire qu'elle a qualifiée de cas horrifiant de féminicide. La victime, Shina B., n'avait que 24 ans. Elle avait signalé à la police des actes de harcèlement et de violence à de multiples reprises. 3 jours avant sa mort, la police avait averti son agresseur, qui est son ex-mari, de rester à l'écart. 3 jours plus tard, il l'a enlevée, torturée pendant 6 heures et tuée. La Cour a reconnu que Shina avait fait tout ce que la loi attendait d'une personne se sentant menacée. Elle a cherché de l'aide, elle a signalé les violences et pourtant, elle est morte. Ses dernières paroles, pas piquées, résonnent comme une accusation. Non pas contre un seul homme, mais contre un système qui n'était pas prêt à la protéger. C'est ce système que nous réformons aujourd'hui à travers l'introduction de ce nouveau texte de loi. Cette législation vise à renforcer les protections juridiques au sein du système. Les victimes doivent pouvoir accéder à des recours juridiques efficaces et à des mesures de protection qui renforcent leur sécurité et réduisent le risque de nouveaux abus. Cela implique de renforcer la protection judiciaire, d'améliorer les mécanismes d'application et de garantir aux victimes un soutien approprié tout au long des procédures. L'amélioration des mécanismes de signalement est un autre objectif majeur de ce texte de loi. Je me réfère à la section 5. Le système est conçu pour rendre le signalement plus simple. En effet, le projet de loi prévoit que toute personne exerçant des fonctions professionnelles ou officielles auprès de victimes potentielles et ayant des motifs raisonnables de croire qu'une personne avec qui elle est en contact a été ou risque d'être victime d'un acte d'abus domestique est tenue d'en informer le responsable de mon ministère et le commissaire de police. Ce n'est pas facultatif. Cette obligation comble une lacune qui a coûté des vies. Madame la Présidente, mon ministère renforcera parallèlement ses campagnes de sensibilisation pour encourager le signalement des cas de violence domestique via la ligne d'assistance 139, disponible 24 heures sur 24 et 7 jours sur 7, ainsi que via l'application mobile L'Espoir. Je lance un appel à tous les citoyens de ce pays. Agissez en lanceur d'alerte. Si vous êtes témoin d'un abus domestique, appelez le 139. Je vous assure que tous les signalements seront traités avec une stricte confidentialité. Madame la Présidente, en outre, en cas de manquement à une ordonnance d'abus domestique signalée à un poste de police, l'officier responsable du poste, indépendamment du lieu où l'acte a été commis ou du lieu de résidence de la victime, est tenu d'enregistrer la déclaration de la victime et de faire enquêter sans délai sur les circonstances de l'infraction. Une victime peut désormais se rendre dans n'importe quel poste de police du pays. Avant ce présent texte de loi, des femmes étaient renvoyées parce qu'elles s'étaient présentées au mauvais poste de police. Cela prend fin. Madame la Présidente, je tiens à remercier le commissaire de police pour sa collaboration et son assistance à mon ministère dans le cadre des investigations menées par la Brigade pour la protection de la famille. Je l'appelle également à veiller à ce que la formation dispensée par Safe Lives UK soit pérennisée par la Police Training School afin que tous les cadres de la police mauricienne bénéficient du même niveau de préparation. Madame la Présidente, la législation est importante, mais si son application ne se fait pas dans l'esprit de la loi, cela ne sert à rien. Face à la définition élargie de l'abus domestique et aux responsabilités croissantes des agents responsables de la mise en pratique, mon ministère poursuivra et renforcera ses programmes de renforcement des capacités afin d'améliorer les interventions et à évaluer les risques. En décembre dernier, mon ministère a bénéficié de l'assistance financière et technique du Fonds des Nations Unies pour la population, UNFPA, pour organiser un programme de formation des formateurs multisectoriel centré sur les survivants en partenariat avec plusieurs parties prenantes, dont des ONG. Par ailleurs, Madame la Présidente, le tribunal disposera dorénavant de 7 jours au lieu de 14 jours à compter de la date de la demande pour convoquer la personne mise en cause et statuer. 7 jours, pas 14 jours comme c'est le cas aujourd'hui, parce que derrière chaque jour gagné, il y a une femme qui dort un peu moins dans la peur. Une victime qui attend n'est pas en sécurité, elle est en sursis. Réduire ce délai de moitié, ce n'est pas une retouche procédurale, c'est reconnaître que le temps dans ces situations n'est jamais neutre. Il peut coûter une vie. Par ailleurs, bien que la durée maximale des ordonnances de protection, Protection Order, demeure de 2 ans, comme dans la loi existante, ce nouveau texte de loi à la section 8.4 va plus loin. Le tribunal, au moment d'émettre l'ordonnance, demandera un réexamen périodique tous les 3 mois pour évaluer le comportement de l'auteur des violences. Ce qui veut dire qu'une ordonnance de protection n'est plus un simple document, c'est un instrument actif et contrôlé. À la place des Occupation and Tenancy Orders prévus par la loi existante, ce nouveau texte de loi à la section 13 introduit des Exclusion Orders. Lorsque la cohabitation continue représente un risque, l'auteur des violences quitte le domicile et non la victime. La section 13.4 prévoit que la victime ne devrait pas avoir à déraciner ses enfants, quitter son foyer, abandonner son environnement en raison de la violence de son conjoint ou sa conjointe. Lorsque l'exclusion du domicile n'est pas possible, le tribunal peut ordonner à l'auteur des violences de pourvoir à un logement alternatif pour la victime. La charge incombe à celui qui a créé le danger et non à celle qui en a souffert. Madame la Présidente, la section 17 introduit un Intervention Order visant à la réhabilitation des auteurs, car un auteur de violence non réhabilité récidivera, peut-être contre la même victime, peut-être contre une autre. Les données sont claires, la sanction sans intervention ne réduit pas la récidive, elle la reporte. C'est ainsi que le tribunal peut ordonner une évaluation psychologique de l'auteur par un psychologue de mon ministère afin de déterminer s'il serait dans son intérêt de suivre un programme de réhabilitation. Sur la base de ce rapport à la section 17.2, le tribunal peut, avant de statuer sur l'ordonnance de protection, émettre une ordonnance d'intervention obligeant l'auteur à participer au programme. Le respect de cette ordonnance est contrôlé et communiqué au tribunal. Le manquement à comparaître est passible d'une amende n'excédant pas 50 000 roupies, comme prévoit la section 17.5. Madame la Présidente, l'abus domestique doit être traité comme un comportement criminel grave. Une personne qui bat sa victime dans la rue fait face à des conséquences. Une personne qui bat sa victime dans l'intimité de leur foyer doit faire face aux mêmes conséquences. Le cadre domestique n'est pas un bouclier, il ne l'a jamais été. En vertu de ce texte de loi, il ne le sera plus jamais. Madame la Présidente, ce projet de loi crée un Domestic Abuse Coordinating Panel. Ce comité sera chargé de coordonner les cas d'abus domestiques signalés à mon ministère, dans les postes de police ou dans toute autre institution et aux ONG traitant ces cas, d'examiner les dossiers qui lui sont soumis et de faire des recommandations aux institutions publiques. En parallèle, le projet de loi prévoit la mise en place des Multi-Agency Risk Assessment Committees au sein de l'ensemble des Family Support Services en vertu de la section 25. Ces comités seront chargés de procéder à des évaluations des risques dans les cas traités par les institutions publiques et les ONG, de définir les mesures correctives à adopter et de soumettre des rapports au Coordinating Panel, comme le stipule la section 27. Madame la Présidente, je souhaite souligner que les contraventions prévues par ce texte de loi à la section 39 comportent des sanctions considérablement renforcées par rapport à la loi existante, avec l'introduction de la servitude pénale pour une durée n'excédant pas 10 ans en cas de troisième condamnation ou de condamnation ultérieure. Toute personne qui omet délibérément de se conformer à une ordonnance en matière d'abus domestique commet une infraction et est sur condamnation passible d'une première condamnation, d'une amende n'excédant pas 50 000 roupies et d'une peine d'emprisonnement n'excédant pas 12 mois, d'une deuxième condamnation, d'une amende n'excédant pas 100 000 roupies et d'une peine d'emprisonnement n'excédant pas 3 ans, d'une troisième condamnation ou d'une condamnation ultérieure, de la servitude pénale pour une durée n'excédant pas 10 ans. Ces sanctions envoient un message sans équivoque. L'abus domestique est un crime et il sera puni en conséquence. Madame la Présidente, la loi est un processus dynamique. Bien qu'il s'agisse d'une législation complète, le Domestic Abuse Act révélera au fil du temps et des cas soumis aux services prestataires des lacunes qui devront être comblées par des amendements appropriés afin de mieux protéger les victimes. Les membres de cette Chambre noteront que 2 éléments importants sont absents du Domestic Abuse Bill, le concept de féminicide et le viol conjugal. Ces questions sont traitées dans le Code pénal présenté en première lecture par mon collègue l'Attorney General. Le projet de loi fonctionne de concert avec d'autres législations afin de couvrir tous les actes répréhensibles, qu'ils soient commis dans le monde physique ou l'univers virtuel. Les préjudices en ligne, par exemple, online harms, est un problème très grave qui est traité dans le cadre de la Cyber Security and Cybercrime Act 2021. Cette législation traduit les auteurs de ces actes en justice et cette loi sera également appliquée dans toute sa rigueur. Madame la Présidente, je conclurai en remerciant toutes celles et ceux qui ont apporté leur contribution à l'élaboration de ce texte. L'Attorney General et ses officiers, les officiers de mon ministère, le Parliamentary Gender Caucus, la Mauritius Bar Council, la Mauritius Law Society et les ONG partenaires, chacun a posé une pierre à cet édifice. Mais mes remerciements les plus sincères, les plus profonds, vont aux survivantes, à celles qui ont eu le courage de s'asseoir en face de nous, de rouvrir des blessures qui n'étaient pas encore cicatrisées et de nous dire « voilà ce que la loi n'a pas su faire ». N'a pas su voir. Voilà ce qu'elle doit désormais protéger. Ce texte de loi, Madame la Présidente, porte leur voix. Madame la Présidente, je pense en cet instant à Natacha Apana, écrivaine mauricienne, l'une des nôtres. Dans La nuit au cœur, prix féminin 2025, elle témoigne de 6 années passées sous l'emprise d'un homme qu'il avait, je cite, « retourné comme un gant ». Une histoire qu'elle appelle, je cite encore une fois, « l'angle mort de sa vie ». Dans ce livre, elle raconte aussi la mort de sa cousine, Emma, tuée en 2000 par son